You want to support Roland Martin Unfiltered? Be sure to join our Bring the Funk fan club. Every dollar that you give to us supports our daily digital show. There's only one daily digital show out here that keeps it black and keep it real as Roland Martin Unfiltered. Support the Roland Martin Unfiltered daily digital show by going to RolandMartinUnfiltered.com. You can make this possible. Folks, a pivotal day in Minneapolis where ex-police officer Derek Chauvin is on trial for the murder of George Floyd. 3 weeks of testimony boils down to final arguments presented by the defense and the prosecution. Here's a roundup.
This use of force was unreasonable. It was excessive. It was grossly disproportionate. It is not an excuse for the shocking abuse that you saw with your own eyes. And you can believe your own eyes. This case is exactly what you thought when you saw it first. When you saw that video, it is exactly that. You can believe your eyes. It's exactly what you believed. It's exactly what you saw with your eyes. It's exactly what you knew. It's what you felt in your gut. It's what you now know in your heart. This wasn't policing. This was murder. The defendant is guilty of all 3 counts. All of them. And there's no excuse. His heart failed because the defendant's use of force, the 929, that deprived Mr. Floyd of the oxygen that he needed, that humans need to live. And Dr. Tobin knows because he is a pulmonologist. He's a lung doctor. But for the defendant's actions, pushing him down, would George Floyd have died that day? Was it drugs? He'd just miraculously die of a drug overdose in that time? Maybe it was the tailpipe. Maybe it was his enlarged heart. Maybe not. Use your common sense. Use your common sense. Believe your eyes. What you saw, you saw. And George Floyd replied, I'm not trying to win. I'm not trying to win. I'm scared. But the defendant was trying to win. He wasn't going to be told what to do. He wasn't going to take a challenge to his authority. He was trying to win. And George Floyd paid for it with his life.
The presumption of innocence, the defendant is presumed innocent. That's the starting point. He's presumed innocent of these charges. And this presumption remains with him throughout the course of the trial, the presentation of the evidence, throughout the course of your deliberations, until and unless the state has proved its case beyond a reasonable doubt. The defendant does not have to prove his innocence. We talked about this in jury selection. We talked about the starting point. The defendant doesn't have to try to catch up. He starts at the presumption of innocence. The criminal case is kind of like baking chocolate chip cookies. You have to have the necessary ingredients. You've got to have flour and sugar and butter and chocolate chips and whatever else goes into those chocolate chip cookies. If you have all of the ingredients, you can make chocolate chip cookies. But if you're missing any one single ingredient, you can't make chocolate chip cookies. It's a simple kind of analogy. But the criminal law works the same way. We say, we call the ingredients the elements. The state has the burden of proving each and every element beyond a reasonable doubt. Not just some global proposition that they've proved their case beyond a reasonable doubt. They have to prove each of these elements beyond a reasonable doubt. And if you determine that they have done so, you convict. But if they are missing any one single element, it is a not guilty verdict. A reasonable police officer understands the intensity of the struggle. You can see at points when Mr. Floyd's legs kick back, it actually almost knocks Officer Lane over. Right? It knocks off the body-worn camera and the badge of Officer Chauvin in this struggle. A reasonable police officer would understand this situation, that Mr. Floyd was able to overcome the efforts of 3 police officers while handcuffed with his legs and his body strength. A reasonable police officer would also consider his department's policies, including the use of non-deadly force policy. Force that does not have the reasonable likelihood of causing or creating a substantial risk of death or great bodily harm. This includes, but is not limited to, physically subduing, controlling, capturing, restraining, or physically managing a person. This is the policy, 5-302 of the Minneapolis Police Department, that non-deadly force can be used to physically manage a person. So throughout the course of this trial, the state has focused your attention on 9 minutes and 29 seconds. The proper analysis is to take those 9 minutes and 29 seconds and put it into the context of the totality of the circumstances that a reasonable police officer would know. And the proper analysis starts with, what did the officers, or what would a reasonable officer know at the time of dispatch?
I'm going to start talking to you about what I call the 46th witness. You actually have heard from 45 witnesses on the stand, but there is a 46th witness. And this witness was testifying to you before you got here to the courtroom. They testified over everybody else's testimony on the stand. It's the only witness that will be talking to you when you're back in deliberation. And that witness, ladies and gentlemen, is common sense. Common sense. We'll continue talking with you all the while, because while you've heard hours and hours and hours of discussions here in the closing, ultimately it really isn't that complicated in what it is you have to decide with respect to the excessive use of force and the issue of causation. In fact, it is so simple that a child could understand it. In fact, a child did understand it when the 9-year-old girl said, "Get off of him." That's how simple it was. Get off of him. Common sense. Why is it necessary to continue applying deadly restraint to a man who is defenseless, who is handcuffed, who is not resisting, who is not breathing, who doesn't have a pulse, and to go on and do that for another 3+ minutes before the ambulance shows up, and then to continue doing it? How is that a reasonable exercise in the use of force? You can believe your eyes, ladies and gentlemen. It was what you thought it was. It was what you saw. It was homicide.
Let's go to our legal panel. Terraine Bailey, attorney, the Bailey Law Firm, Candace Kelley, legal analyst, and Monique Pressley, legal analyst and crisis manager. Glad to have all of you here. First off, Candace, I'll start with you. Your assessment of closing arguments today. I got the sense that Chauvin folk were all over the place. I really wasn't quite understanding what the hell they were talking about.
Yeah, they really didn't give a coherent argument in terms of what we saw Jerry Blackwell do at the end on his rebuttal. We saw how he just decimated their argument and went step by step as to what they were trying to present, and basically saying, like the soundbite said, just listen to your common sense. They're going to talk to you about causation. They're going to talk to you about heart disease and meth and fentanyl. They're going to talk to you about exhaust, right? Carbon monoxide. But when we look at that, all of those Jerry shredded. And I think that we got not only just a good idea about what jurors were going to have to grapple with, but what just good lawyering is overall. We saw that there was a good story to tell, and Jerry Blackwell especially told it very, very well.
Monique, your assessment?
I think the prosecution as a whole did its job and did certainly enough to get the desired and proper outcome, which is guilty. It should be on all 3 of the charges. The defense has been just borderline abysmal throughout and today was no different. They've resisted every urge to make coherent arguments. They've resisted every urge to try to actually put through the type of analysis and factual debate that would lead to a reasonable doubt. The entire time it's been grasping at straws, it's been conjecture, it's been hypotheticals, and I just pray that that was not effective for a single juror.
Terraine, you have been quite critical of, as a defense attorney, what you have seen from the Chauvin defense team. Again, your assessment of these closing arguments today.
One of the things you learn when you become a defense attorney is that when you're presenting your case to the jury, you need to tell a coherent story. You need to have a theme and a theory. There was none of that here. They just threw everything from beginning to end just up on the wall, hoping it would stick. We heard everyone blamed from the perspective of the witnesses, from the EMTs not arriving on time to exhaust fumes being the reason why this man, George Floyd, is dead. We heard everything but a reasonable explanation why this evidence doesn't support a conviction. And it's very disappointing to see a defense attorney go out there and do a subpar job. I mean, every defendant deserves to have competent counsel, and that did not happen here.
When we talk about, when we start breaking all of these different things down, what was very interesting as I watched these closing arguments, how the prosecution, Candace, just completely said, they talked about drugs, 1 pill found. They talked about this drug, trace amount found in his body. They talked about this. No, you just don't just die arrhythmia just for the hell of it. I mean, it was. I mean, I was sitting there going, man, my man is just sitting there just crushing every single thing they threw out.
Oh, yeah, absolutely. You know, I don't know what he had for dinner, but for lunch, he had that defense every time he came up to speak about what was going on. I think one of the most interesting things, too, was this visual that he had where he broke down George Floyd's life in 10-minute increments to get rid of this argument that maybe everything just culminated at once and everything coincidentally happened at the same time, that he just died at the same time that the knee was on the neck, but it's not because of the knee that was on the neck. So seeing that one dot on the screen represent his, excessive force and break it down that way. He was just a good storyteller. He really captivated you. And when you look at Eric Nelson, I mean, he hasn't been a bad storyteller up until this point. But here, you have to believe in your argument so that the jury can believe in your argument. And we didn't see that. I didn't see a lot of faith. I didn't see a lot of what he had in his opening argument. If you go back to the opening arguments and look at all the promises that were made by the prosecution and the defense, this is where at the end of the story, we have to make good on the story. I mean, we didn't see Maurice Hall. As you mentioned, all of the arguments were just disintegrated, and he just didn't rise to the occasion. And this is something that I think that the jury is going to more than take into consideration. Jerry Blackwell was the last person that they listened to. This is the person that they're in deliberation room right now up until 7 o'clock to figure out, what's going on. And when you have Jerry Blackwell's voice in your head, like he was giving off today, it can't but echo and just ring the truth that the prosecution wants the jury to hear.
And to that particular point there, Monique, in terms of what was laid out, from your vantage point, put yourself in the seat of that jury. You're sitting there, you're listening to these arguments being played out, you're listening to what is being said. How do you assess, again, put yourself in the place of a jury, how do you assess that?
I think that jury likely has been ready. And so that's why I was amused by defense counsel Nelson's arguments at the end about how they should have been sequestered all along and et cetera. Listen, the agitation that he was getting before lunch that was obvious to everybody in the courtroom from that jury would have been 3 times as bad. This has, as we learned, they've had 40 plus witnesses, and there's been more than enough evidence for each of the elements of each of the charges. And that's why I thought that lead counsel and Scheicher did an excellent job of being forceful, being emphatic, but being very measured and very calm at the same time, utilizing appropriate changes in pace and vocal inflection in order to, without yelling at jurors, because they can't stand that, without doing that, actually going methodically through piece by piece. And as the other counsel on the panel have said, it was just unanswered. And I agree that that is shameful. I've been a criminal and civil defense attorney for 22 years, and that is not what meets constitutional standards of adequate defense. And as I have said all along, I've been looking at it thinking, are they going for insufficiency of counsel? Because this is a terrible job. So without being able to actually look at the jurors and see who was paying attention and who wasn't, all I could say is I know that they heard enough, and I couldn't understand for the life of me why defense counsel kept insisting on playing that video. That video was murder to their case, and there was no shine that they could put on any part of it that assisted them. I would have had to been forced to play that video on cross. I didn't understand it watching any day of the trial, and I didn't understand it today. I'd be like, what video?
The one of the things that was interesting took place, Terraine, when it came to this nonsense dealing with Congresswoman Maxine Waters. Okay, before I play that, at noon, when they broke for lunch, there was a news conference. The George Floyd family, attorney Ben Crump, Congresswoman Joyce Beatty was also there. Reverend Jesse Jackson Sr. Here's what Congresswoman Beatty had to say.
Thank you. I'm here on behalf of our 56 members of the Congressional Black Caucus, several of them with us today. We come today in solidarity with the Floyd family, with all of the street fighters, the activists, the congressional people, because today it is not Minnesota versus all police. It is about Minnesota versus Derek Chauvin. And in the words of George Floyd's daughter, my daddy will change the world. This verdict today changes the world. Thank you.
All right, folks, back to our Roland Martin Unfiltered video in just one moment.
It's time to be smart. When we control our institutions, we win. This is the most important news show on television of any racial background. Y'all put $2, $3, $4, $5, $10, $15, $20, $30 on this and keep this going. What you've done, Roland, since this crisis came out in full bloom. Anybody watching this, tell your friends, go back and look at the last 2 weeks, especially of Roland Martin Unfiltered. I mean, hell, go back and look at the last 2 days. You've had sitting United States senators today, Klobuchar and Harris. Whatever you have that you can bring to Roland Martin Unfiltered to support it, please do, because this information may literally save your life.
Watch Roland Martin Unfiltered daily at 6 p.m. Eastern on YouTube, Facebook, or Periscope, or go to RolandMartinUnfiltered.com. Support the Roland Martin Unfiltered Daily Digital Show by going to RolandMartinUnfiltered.com. Our goal is to get 20,000 of our fans contributing $50 each for the whole year. You can make this possible. RolandMartinUnfiltered.com.